given all the risk and liability, I wanted to go through with you the proper steps for personal injury firms in terms of the initial reporting and resolution ultimately of conditional payments. So this slide gives you an overview of the process from the plaintiff's perspective that has to happen for resolution of conditional payments. So it starts off with reporting the case to the BCRC, and that requires proof of rep and consent forms being sent to Medicare when you begin to represent a Medicare beneficiary. The BCRC will then issue a rights and responsibilities letter. That letter is kind of the initial starting point. If you don't get that after reporting, that means that something happened along the way and you need to make sure that you resubmit your reporting documents to Medicare. Once you get the rights and responsibilities letter, from that point forward, you want to use Medicare's correspondence cover sheet. At the bottom of this slide is a URL, and you can Google to and find all of the documents on Medicare's website that you need to be using as part of your communications with Medicare. So after the rights and responsibilities letter, 65 days thereafter, Medicare will give you an interim recovery amount by issuing a CPL, conditional payment letter. That was the letter I was saying that in the previous slide, the firm relied upon that in settling the case. You can't rely upon that. It's simply an initial amount. From there, you want to audit that and dispute any unrelated charges. If it's exceedingly low and you know there's been treatment, either one or two things have happened. Either Medicare has not gotten all of the information yet on those treatment dates, or it could be that your client switched over into a Medicare Advantage plan, Part C plan, and I'll talk about that in a moment. But just remember that if the care isn't showing up on the CPL, that doesn't mean that when it comes time for settlement, that number won't grow substantially, because when you give Medicare all the settlement details, that's when they'll issue the final demand. At that point, that's when you know you have a number from Medicare that you can rely upon and is not going to change. So some key takeaways from what we've just talked about is that ultimately, once Medicare issues the final demand, you only have 60 days to pay that debt, or it will accrue interest. And interest starts from the date of the final demand, but it's only assessed if not paid within 60 days. Remember that requesting an appeal or compromise or waiver does not toll the interest from running. It will keep accruing, and it's due and payable for each full 30-day period the debt remains unresolved. Once the 90 days post-final demand expires, the matter gets referred over to Treasury, and then you have a whole mess, because once it gets over to Treasury, it's very difficult to ultimately deal with the situation. Now, once payment is made and Medicare receives it, they'll send a letter stating that ultimately the conditional payment has been reduced to zero and the case is closed for Medicare.